Good evening. Hi, welcome. On behalf of the League of Women Voters of Wellesley, I want to welcome you to our 2025 opening meeting, Courts and Consequences, Understanding Legal Power in the U.S. Today. This program is being recorded by Wellesley Media. I'm Ann Mar-Alonza, and I'm on the steering committee of our local league. And I want to introduce you to some of our other board members who are here tonight. So when I call your name, please just wave. So we have Rekha Sampath, over here, Jessica Graham, Ellie Perkins, Deb Codispoti, Diane Heeman, Sue Mangiucati, and then not here, Philippa Biggers, Eileen Nielsen, and Louisa Herman, who are unable to join us tonight. Some of you are League members. For those who are less familiar with the League, we are a grassroots organization of women and men dedicated to voter rights and voter education. For over 100 years, the League of Women Voters has been a leader in working to ensure that citizens have a role in making democracy work. It is our mission to promote political responsibility through informed and active voter participation in government and to influence public policy through education and advocacy. The League of Women Voters is a nonpartisan group, which means that we never endorse specific candidates. However, once someone is elected, we do hold them accountable. Our advocacy is issue-oriented based on comprehensive study and a consensus among our membership. If you are not yet a member, we welcome you to join us. Information on how to join is available at the table over here. Please feel free to ask questions of any of the board members. And for further details on our programming, you can visit our website, lwvwellesley.org, or follow us on Facebook or Instagram. I want to share one upcoming program, open only to members and their guests, a private tour of the Boston Public Library on October 17th. We're going to visit areas of the library not open to the public. You might have read yesterday's Boston Globe article highlighting some of these special places. If you want to come to this tour, make sure your membership is up to date and email us at lwvwellesley2@gmail.com. Also in October is the next Rally for Democracy on October 18th. There are some flyers over here. Please take one and you can post it somewhere. Share it with your friends. I want to remind you that democracy is not a spectator sport. Please get involved in your local government and let your legislators know what you think is important. The topic of tonight's program is important to me. Oh, and by the way, all of this information is also on the table. So if you, and all of these QR codes take you to our website. So all of that you can get later. So the topic of tonight's program is important to me. Like many of you, I have watched the news over the past 9 months, trying to understand the impact of executive orders, DOGE cuts, and ever-changing tariffs. What concerns me the most, however, is the seeming lack of respect for decisions by the courts. Doesn't one have to follow court orders? What happens when one does not? And where is the balance of power that we count on in our federal government? We are so fortunate to have with us tonight Tom Burke, the Ralph Emerson and Alice Freeman Palmer Professor of Political Science at Wellesley College. Professor Burke's research focuses on the role of rights, courts, and legal reasoning in American politics, and on the ways in which organizations respond when faced with legal and political demands to change practices. Professor Burke has published numerous articles and books, including How Policy Shapes Politics and Lawyers' Lawsuits and Legal Fights. At Wellesley, Professor Burke teaches Introduction to American Politics, Public Policy in American Politics, Health Politics and Policy, and Legal Research. For fun, he tries as much as possible to run and bicycle, both on and off-road. He loves fine wine, is learning to be a photographer, and spends plenty of time with his daughter, Aria. After some brief remarks, we are going to invite Professor Burke to engage with us in discussion, during which there'll be plenty of time for your questions. Leading that discussion will be League of Women Voters of Wellesley member Rama Ramaswamy, who might just be the most accomplished woman that I know. Rama is an author, educator, lecturer, scientist, both biology and geology, and multimedia journalist with 20 years of experience in TV, radio, and print journalism. Rama has worked for the U.S. Geological Survey and continues to work with nonprofits specializing in legal, charitable, educational, and social work areas. You might recognize Rama from Wellesley media broadcasts or from events hosted by World of Wellesley, an organization dedicated to making Wellesley an inclusive community for all, for which she serves as president. Or perhaps you've read her poetry book. Thank you, Rama, for hosting tonight. So now, without further ado, I'm going to turn the podium over to Professor Burke. Welcome.
Academics aren't always given to concision, but I'll try to be brief and not bore you with opening remarks. But I did, and during the conversation and in Q&A, we can talk about any aspect of legal power in the United States or how courts work. Any questions you have, I'm happy to at least try to answer. I'm teaching constitutional law this semester, and I sometimes feel out of my depth. The book we have is about this thick, and I think I know about this much of it, but I can fake it on a good day. So, so I wanted to use my opening remarks to touch on some things that maybe aren't very well understood by the public about the conflicts that are going on, the legal conflicts between Donald Trump and all kinds of organizations, and how the courts are handling them. So that's what I'm going to talk about today, and it does illustrate some of the issues with courts and legal power that we have in the United States. And I'm going to make 3 take-home points. You know, they say even in an hour and 15-minute class, you really can only teach students 1 or 2 things. So, and some days you're not sure you even got those things over. I'll try in 20 minutes to make 3 points. One is, Trump is losing in the legal system a lot more than you may realize, and I'll explain why. But this part I think you appreciate, but I'm going to fill in a little bit. Trump is taking advantage of the slowness of the legal process, and this is an important point, the institutional weaknesses of the judiciary, and I'll say a little bit more about what I mean by that. There are so many lawsuits against the Trump administration. You can go on the web, and if you just Google Trump litigation tracker, there's several organizations now that do these litigation trackers. This is one of them. This one counts over 400 different federal lawsuits percolating through the courts, challenging different aspects of the Trump administration's actions. Now, we could have had a Biden administration tracker, and there would have been quite a few of those too, but not 400. There's a lot more, and we're only a few months into the Trump administration. Trump's mostly losing. And this is a little bit obscured because lower federal court rulings don't get that much attention. I couldn't get an update through September. This is from earlier in the year, but you can see he's actually the loss record is getting worse and worse over time. And I'm not sure it's actually, if we filled it in through June, July, August, that it would look much different. What's kind of interesting is the lower federal courts in the United States, the trial courts in the United States, there's about 800 federal district judges spread all around the United States. They're kind of divided almost 50-50 between judges who were appointed during Republican presidencies and judges that were appointed during Democratic presidencies. But Republican appointed judges and Democratic appointed judges kind of agree. They both rule overwhelmingly against the Trump administration. And this is from a different time period, so it's got an even more skewed number. 94% of cases during this time period were decided against the administration. But you'll notice the Trump administration not doing too well in the federal district courts, still not doing very well in the next level of appeal, which is the circuit courts of appeal. But then, all of a sudden at the Supreme Court, doing really, really well. So I'm going to explain that. Because, well, I'm not going to explain that because to some extent it's a mystery, but I'm going to explain the context of what's going on. Because I think overwhelmingly what you tend to hear about is this, and you don't hear as much about what's going on at the lower court level. And one thing, well, we'll talk a little bit more about this in just a moment. Now, to understand what's going on between the Supreme Court and the lower courts, we have to explore something that in the legal world they now... Oh, you want me to use the microphone? Yeah, okay. We have to, I'm usually so loud that it doesn't matter, but okay, I'll talk on mic. In the legal world, this is a well-known term, and I think it's starting to diffuse out to the public, the shadow docket of the Supreme Court. You might know that the so-called normal way the Supreme Court makes decisions is that they mostly get to pick the cases they will hear. One of the funny things about the Supreme Court is they used to hear 150, 140 cases a term, and those guys, they're like college professors with tenure. They have lifetime behavior, lifetime job. So no one controls how much work they do. They're down to 70 cases a year that they hear fully. Those cases, people write a brief explaining why they think the lower court decision was either wrong or was correct. And then they have oral argument at the Supreme Court. There's a very elaborate procedure for those cases. What some law professors noticed was there was a whole nother set of decisions that the Supreme Court made much more hastily, with much less attention, and they called that the shadow docket because it was in the shadows. And the most controversial part of the shadow docket is emergency applications. And when I showed you that the Supreme Court was siding with the Trump administration, all of those cases were on the shadow docket. They were not regular, fully decided cases. So let me explain what the emergency application process on the shadow docket is. If you have a case in the lower court and you say, oh my goodness, the Trump administration wants to deport my clients to South Sudan, right? And we're making an argument that they're wrong. But if they deport them while we're arguing, then it's going to be really hard to solve the problem. So I want an injunction to stop you from doing anything while the case is pending, okay? So this is a very common maneuver that litigants take, which is, while the case is pending, let's just stop. Don't allow anything to change, okay? That's an injunction. Okay, so a lot of times lower courts are granting these injunctions. There's 95% win rate. That's almost all in injunctions. And then the government, the Trump administration, appeals to the Supreme Court and it says, we want a stay of the injunction. We want to go ahead with the deportation, or we want to go ahead cutting the education department, or we want to go ahead defunding the researchers in the NIH. We don't want this injunction to remain in place. And the Supreme Court then either grants that stay of the injunction or rejects it. And these emergency stays of injunctions are the most controversial part of the shadow docket. Now, why are they controversial, especially among lawyers? First of all, they're usually decided without oral argument. There's not a long process before the Supreme Court decides these cases. After all, they are emergency cases, right? When they decide them, they're not deciding who is going to win the case. That's supposed to be a factor. They're supposed to take a preliminary estimate, but they're also supposed to decide whether irreparable harm will be done to either side while the case is pending if the injunction is removed, right? Okay. And they're also supposed to decide, if we act now, who's it going to hurt more? Which side will be hurt more? Now, when the court rules on these cases, unlike I'm inflicting Supreme Court opinions on my students this semester teaching constitutional law. I can tell you we edit them way down, because if they had to read the opinions, they would go nuts. I mean, they're often over 100 pages long. So we give them only the good parts, right? So Supreme Court opinions, Supreme Court arguments, these people write on and on and on. There's a lot of complexity in these lawsuits. But in these cases, the rulings are short. Sometimes there's no reasoning at all, and you don't even know how the Supreme Court voted in the case. They don't release the votes. The rulings aren't, unlike regular Supreme Court rulings, supposed to set precedent, although there's this weird thing lately where the Supreme Court's been telling judges, haven't you been paying attention to what we did in the other cases? Which, again, were emergency cases, so technically aren't supposed to set precedent, but anyways. And remember, this is not a ruling on the case itself. The case is still percolating through the courts. It's just a ruling on the injunction and whether the injunction should be stayed. Okay, so this is a lot of detail. Oops. Let me show you one recent case. This involves basically shutting down the education department, firing 1,400 employees. And what lawyers for the fired employees did, they went to the district court and said, well, it's going to take a while to decide this case. While we decided, how about you don't get to fire all these people? Because if you fire everyone, it's going to take 2 or 3 years for this case to resolve. And by then, everyone will have scattered to the 4 winds. Let's have an injunction while the case is pending. District court judge agreed with that. Appeals court judge agreed with that. The Trump administration appealed it to the Supreme Court, and here's the ruling in its entirety. This is the ruling in its entirety. It says, basically, this is granted. That's what it says. Now, as you might imagine, the people who on the Supreme Court who don't like some of these things, often the 3 Democratic appointed justices, Sotomayor, Kagan, and Ketanji Jackson, they often dissent from the court's opinion granting this stay. And this is, some of the dissents are pretty strongly worded. Here's one of them. When the executive publicly announces its intent to break the law and then executes on that promise, it is the judiciary's duty to check that lawlessness, not expedite it. 2 courts rose to the occasion, preliminary enjoining the mass firings while the litigation remains ongoing. Rather than maintain the status quo, however, this court now intervenes, lifting the injunction and permitting the government to proceed with dismantling the department. That decision is indefensible. It hands the executive the power to repeal statutes by firing all those necessary to carry them out. The majority is either willfully blind to the implications of its ruling or naive. But either the way, the threat to our Constitution's separation of powers is grave. Unable to join in this misuse of our emergency docket, I respectfully dissent. This is not the most strongly worded of Sotomayor's, but believe me, if you want to read some really, really strongly worded dissents, they've been issuing from that wing of the court lately. It's also interesting to compare, because, the same thing I told you, the Biden administration was regularly sued, and there was regularly an attempt to enjoin the Biden administration to do anything while the case was pending. An example was the student debt relief case. You might have heard about that, where the Supreme Court eventually on the merits decided that the debt relief couldn't be granted. But before that, they got an injunction stopping the Biden administration from moving forward while the case was pending. So if you look, the red is the cases where the government had the injunction, where the injunction was maintained. The green are where the injunction was lifted. And you can see the record across the 2 administrations is quite stark. And remember again, this isn't about the merits of the actual lawsuit. It's about the injunction itself, whether irreparable harm will be done while you're waiting for the underlying lawsuit to get settled. So it is kind of striking how big a disparity there is here. And this situation where the Supreme Court is constantly staying the injunctions issued by federal district judges, and sometimes even upbraiding federal district judges and saying, well, what were you thinking? Which happened a couple times recently. And by the way, it was to a Massachusetts judge, William Young, who was a Reagan appointee, and Stephen Breyer, who's the retired Supreme Court justice, who I think lives in Massachusetts, actually leapt to the defense of Judge Young. But the judges, there was an article I noticed on NBC saying that they kind of talked anonymously to some federal district judges. And in this article, it says 10 of the 12 judges who spoke to NBC News said the Supreme Court should better explain these rulings, noting that these terse decisions leave lower court judges with little guidance on how to proceed. But they also have this new and concerning effect, validating the Trump administration's criticism. To the extent they're upbraiding these lower court judges for not following the law, they're saying we're being hung out to dry by the Supreme Court here. We're just trying to do our job, but they're trashing us. So, okay, so there's all this byplay going on between the Supreme Court and the lower federal district judges. But that should not obscure the fact that, first of all, the government continues, the Trump administration, to lose in the lower courts. And a lot of times it's not even bothering to seek emergency relief. And it's mostly complying with the rulings that lower court judges are making. And this is a judge, this is a law professor who is very useful, really good authority on what's going on in the federal courts right now, Stephen Vladek over at University of Texas. And he says, because this reality doesn't make for attractive headlines, it's one to which too many folks are largely oblivious. Mostly the Trump administration is losing in the federal courts. Let me give you an example. This one you might have heard about, the so-called birthright citizenship case. And there was a Supreme Court ruling which I think was overinterpreted. It was interpreted as saying, well, from now on there won't be preliminary injunctions that are effective broadly, nationwide injunctions that federal district judges could do. And there were a lot of headlines to this. And Trump himself said that was a great win at the U.S. Supreme Court. Well, what happened? Actually, right after that, new lawsuits were filed because, in fact, the court ruling did not stop injunctions in the birthright and citizenship case. And in fact, right now, we have a nationwide injunction against moving forward in the birthright citizenship case. And in fact, the Trump administration is going back to the Supreme Court to get these new injunctions lifted as well. So another question you might ask is, what's going on at the Supreme Court where their pattern is so much to overrule these lower federal court judges, including a lot of pretty conservative lower federal court judges that were appointed by Republican administrations? And again, this pattern has to be explained. Well, I can think of three explanations. One is maybe the justices simply feel on the same side as Trump. They think overwhelmingly Trump's going to win these cases, and therefore, why bother with these injunctions? Because we know what's going to happen ultimately at the end. I think that's, there's probably some mix of all these things. One interesting feature of the Supreme Court when it comes to the Trump record is that the justices on the Supreme Court, Alito and Thomas, who most consistently and emphatically side with the Trump administration, were not appointed by Trump. And Trump's own appointees, especially Amy Coney Barrett, and to some extent Gorsuch and Kavanaugh, have on occasion voted against Trump. So it's an interesting pattern. There's also, among the 6 Republican-appointed justices on the Supreme Court, it varies among them, but some feeling that traditionally courts have not given the executive branch enough power, that the Constitution's been interpreted wrongly, and that the executive branch actually deserves more power than it's been given. But there's a third possibility, which is that the justices are scared. Now, why would they be scared? Well, this is the question they have to be asking themselves. What happens if we make a ruling and the Trump administration just ignores it? What happens then? Federalist Papers number 78, the least dangerous branch. This is, I always drill this into my students' heads. This is Alexander Hamilton trying to calm the fears that were being flamed by people who were against the enactment of the Constitution. They said, you're going to create this new federal judiciary, they're going to take over everything. And Hamilton said, calm thyself. This is the least dangerous branch. Why? Because they don't have the power of the purse like the Congress. They don't have the power of the sword like the executive. They don't run the military. They depend on the aid of the executive arm even to have their judgments enforced. They will always be institutionally the weakest branch. And throughout history, we've seen moments when it looked like political leaders would just ignore the judiciary. And this is a famous one. Orville Faubus, the segregationist governor of Arkansas, said, you know what, we're not going to desegregate the schools in Arkansas. We'll just defy you. And that was only overcome because President Eisenhower said we're going to enforce the Supreme Court's rulings by bringing federal troops to Little Rock, Arkansas. Right? So ultimately, the Supreme Court at that crucial moment depended on the executive branch to enforce its rulings. But what if you're telling the executive branch what to do and the executive branch ignores you? And you don't also currently have much support in Congress, right? So when we think about this as political scientists, what are the kinds of cases where the Supreme Court is in a powerful position to enforce its rulings, and when is it in a relatively vulnerable position to enforce its rulings? And I see I'm going over time, so I'm so sorry, but I'll speed it up here. One is, how easy is it to, and this might be some of what's going on in the Supreme Court justices' minds. Where should we make a stand? Where should we tell the Trump administration, sorry, you can't do this, and believe that they will comply? One is, how easy is it to enforce compliance? You know, some kinds of things are very easy to enforce, others are hard. Desegregating the schools, not easy, right? Is our position going to be popular with the public? How will we poll? What is the attitude of other political elites? Will other people in the political system support our ruling? And how is our standing versus the people who are saying they are not going to comply? And here we have bad news and good news for the Supreme Court. The bad news is they've never been less approved of. They have taken their popularity way down. We've never really seen a time, probably since the 1930s, when they were in less esteem than today, largely because of their ruling in the Dobbs decision and the getting rid of Roe versus Wade. But Trump is even more unpopular. Trump is breaking his own records now for unpopularity early in his administration. So he's also not very favorably liked by the public. So, just to summarize, Trump is losing more than you think. Trump is taking advantage of the slowness of the legal process and perhaps some of the institutional weaknesses of the judiciary. Thanks.
That was a lot of information.
Yeah, that might have been too much. Sorry.
It's good. See? Get public opinion. They all loved it.
All right.
So I'm gonna start off with a question for you on precedent, if that's okay.
Use the microphone.
Oh, yeah.
Thank you, thank you. Can you hear me? Perfect. So on precedent, when the Supreme Court overturns its own past rulings, are there any limits on that power?
Not at all. And, you know, the argument is always that the fact that someone back then screwed up doesn't mean we should continue screwing up, right? So and especially in constitutional law, because it's so hard to amend the Constitution to correct a bad ruling. Because if, let's say, the Supreme Court gets it wrong in terms of a statute and what the statute means, relatively speaking, Congress can pass a new statute that says, hey, you bozos, this is what we meant, right? So that's relatively easy. To amend the Constitution is really hard. So the Supreme Court often gets the last word on what the Constitution means. If, as a justice, I look and I say, wow, this precedent has stood for a long time, but it's just wrong, why would I stick with the precedent? And the only possible answer can be that there are reasons generically to stick with precedents, like people have planned their life around the precedent. In business law, contracts law, you don't want to change contracts law too quickly because contracts have been signed with certain understandings in place. And that can happen when it comes to constitutional rulings. And you do have to worry that if the court is flipping back and forth like a weather vane, that it impairs the legitimacy and standing of the Supreme Court. So you do have things to weigh, but you should not, most law professors and people who study constitutional laws say, of course, the Supreme Court, when it feels it's made a mistake, should correct that mistake.
Excellent. So Congress versus the court. Can Congress pass laws that effectively overturn a Supreme Court decision?
Well, that's complicated. If it's a constitutional law decision, it is pretty hard to overturn the constitutional decision. However, if you look at the constitutional article that deals with the judiciary, I was just showing it to my students in constitutional law. It's surprisingly short. You know what it says? Well, there'll be a Supreme Court, and that Supreme Court will handle cases, and then it goes through some kinds of cases. And that's about it. It doesn't say how big the Supreme Court is, so you can add or maybe subtract justices at will, and there's nothing holy about 9. We've had 6, we've had 8, we've had 10 in the past. We've stuck with 9 for a while now, but there's nothing holy about 9. It's not in the Constitution. All the lower courts are created by Congress, and they can create new lower courts anytime they want. They also get to decide what cases the Supreme Court hears. So, for example, it is theoretically possible for the Congress to say, you know, we don't like these gun control rulings that the Supreme Court's been doing. We're going to pass a law saying, from now on, Supreme Court, you can't hear cases involving gun control. Now, the Supreme Court might try to get in there and say, well, that's unconstitutional, and you could have some back and forth over that. But Congress actually has a little bit more power than people realize over the judiciary.
Excellent. So this one's about birthright citizenship.
Cool.
If the court rules against birthright citizenship, what happens to people already granted citizenship? And if a birthright or a birth certificate is no longer able to prove that, then what would?
Right. Boy, to me, this feels like science fiction because I'm just really struggling to figure out how they're going to rule against birthright citizenship. It's literally the words of the Constitution say, all persons born in the United States are citizens, right? It's hard to get around that language. Lawyers are really good at finding ways around language, and maybe there will be a way. But one question about that is, what categories actually are we talking about? Are we talking about people who are here illegally, and then maybe you can say in some metaphysical sense their children weren't born in the United States? I don't know. Or are we just talking about people who are here, mothers who are here on visas right? Temporary visas or something like that. Or is it everyone who's not born to a citizen, which would be a really large category? I mean, there's a lot of ways to go with this, so I don't actually know where that would be. And your question is a very good one. How retroactive would it be then? I don't know. I mean, we're just operating in kind of science fiction language here, so who knows what the answer to that would be.
So excellent. About shadow dockets.
Yeah.
So I know you've sort of explained what shadow dockets are, but I think I was wondering how it's been used historically versus how the Roberts Court is using it now. What's different about the way they're using it now, and what are the implications?
Yeah, well, that's another complicated question. Okay, so first of all, the shadow docket includes everything that the Supreme Court does besides deciding those 70 cases with full argument on the merits, the real full-time job of the Supreme Court. So it includes things like admitting people to the Supreme Court bar, or saying who can argue before the Supreme Court, or a million different little decisions and things. Why has the emergency application part of the docket become such a big deal? There always was an emergency docket. Okay, and you guys probably heard about it mostly in cases of executions, because people would make a last-minute argument to the Supreme Court, stop my execution, it's about to happen in the next hour. Inevitably, they would, right? And this goes back to way before the internet. And it would happen sometimes over the summers when, like tenured college professors, the justices don't work, they're on vacation, they're hanging out. So you'd have like Justice Douglas, who was loved the environment, who would be out camping somewhere, and someone would show up and say, you just got this. It's a death row stay. And the justices actually were empowered to act on those individually. And they still could, actually. In form, they go to one justice, not to the whole court. But over time, and especially I think as the electronics developed and it allowed for more consultation as the internet developed and everything, the justices decided it was bad form for one person to make this decision, that it should be across the whole court. So they started deciding these cases across the whole court. So that's true even for the death row executions. But the other thing that happened was the courts became more and more engaged with these major political issues. And state attorneys general, like Maura Healey here in Massachusetts, became much more involved in suing the administration to stop whatever policy initiative they were engaged in. It started maybe in the Reagan administration, but it really heated up, I would say, during George W. Bush and then Barack Obama. So you have a lot of these cases filed against the administration, and then they try to get an injunction. So now you're not just talking about death row cases, you're talking about major public policy issues involving immigration, climate change, all kinds, environment, abortion, civil rights, all kinds of issues. And so there's much more attention put on these cases. They become much more important. The pandemic was another thing. I mean, obviously the pandemic, I taught a class on pandemic law, and we actually wrote a little book together on pandemic litigation. And during the pandemic, people would make emergency claims. And again, this really got a lot of attention, not just for the emergency docket, but for the phenomenon, which was controversial among Democrats and Republicans, that one federal judge could issue a nationwide injunction, right? So what Republicans would do was trundle off to some district down in Texas, get the most conservative judge they could imagine, and say, hey, you got to stop this, right? Meanwhile, the Democrats, when the Republicans were in power, they trundle off to the Bay Area, get the most liberal judge you could imagine, say, you got to stop this, right? And one judge would do these nationwide injunctions. And then the only way to get relief from that was to go in emergency application and take a stay. All right, this is a long-winded explanation, but you could see the elements of this that are coming together to make this such a conundrum, because now the Supreme Court, it seems like a lot of its business these days is on that emergency docket, rather than what we think of as what the Supreme Court should be deciding, which is full-on cases that have been briefed and they've had a full oral argument about.
Sounds good. So one more question, then maybe we can turn it over to all of you. So checks and balances. So what role do lower courts play in checking the Supreme Court's decision? And an addendum to that is about public trust. So how do controversial rulings affect public trust in courts, and does that matter to judges?
Well, you don't ask any easy questions, do you?
These are from the board members from the league, so.
You only ask the hard ones. Let's see. So the first one was about, do lower court judges check the Supreme Court? Well, you got to realize there are hundreds of thousands of cases filed in federal district court each year. And I just told you that the Supreme Court has gotten lazier and lazier over time, so they're down to 70 cases that they fully decide. So practically speaking, they only get to weigh in on a tiny, tiny percentage of all the cases that are decided in the federal system. Now, there's a norm among lower federal court judges that they're supposed to follow their best understanding of what Supreme Court precedent is. They shouldn't say, well, I think the wind's blowing this way, and I think the Supreme Court's going to change its mind, so therefore I'll rule this way. No, they should rule according to their best understanding of current precedent. It's not their job to change precedent. When you asked about should the Supreme Court change its precedent, yes, the Supreme Court should. Lower judges should not be doing that. They should be following what the Supreme Court says. But there's tons of gray area, right? There's new issues that pop into the judiciary all the time. And federal courts around the country are going to decide those issues. And practically speaking, there's not much the Supreme Court can do about it. They only get to decide a much smaller subset of cases. What do judges worry about when it comes to public opinion? It's hard to know for sure. We can show you as political scientists that historically the Supreme Court mostly kind of follows public opinion, much more than people realize. Some of the cases that people think of as going against public opinion on the side of the underdog, kind of misnomers. Like Brown versus Board of Education, desegregating the schools, was probably the majority view on the day it was decided in the United States. Now, what the Supreme Court tends to do is nationalize things. So there were certain parts of the country in which Brown versus Board of Education was very unpopular. And what Brown and a lot of Supreme Court rulings do is to take the national public opinion and apply it against parts of the country where it's not the majority opinion. But the courts don't tend to act very far out of line with public opinion, and when they do, it can create a crisis. And if you took a good history course, that's what happened in the 1930s when Franklin Delano Roosevelt, in reaction to the Great Depression, initiated a whole series of huge federal government programs that really changed the traditional understanding of the balance between the federal government and the states, and also the balance between private industry and government power. And when Roosevelt did that, the majority of the justices were enforcing the older constitutional view, and they started striking down left and right Roosevelt's policies and the Democrats' policies. And this provoked a crisis. We don't know where public opinion was at the time, but we know that the Democratic Party was very ferociously, profoundly opposed to the federal judiciary and what it was doing, and eventually intimidated the justices into siding with them, because one of the swing justice switched his vote at a key moment and started siding with Franklin Delano Roosevelt and the Democrats. And then these old geezers died off, and Roosevelt was able to replace them with people more sympathetic to his view of things. But for a moment there was a real crisis on the court. We have some articles suggesting that there's maybe a similar crisis of legitimacy with the Supreme Court with the Dobbs ruling. which wasn't just opposed by a majority, but very strongly opposed, such that it created more support for things like, maybe we should be able to fire Supreme Court justices. Maybe we should be able to add a lot more justices. Maybe we should be able to put limits on what justices can decide. And that's the kind of thing where if that kind of view grows and grows, that's the end of the Supreme Court and its power. So if you're Chief Justice Roberts, you do have to worry about this kind of thing getting out of control because, again, institutionally, the judiciary is the weakest branch.
Great. Awesome. And should I walk around with the mic? Or okay.
Do you want to walk around or do you want me to walk around?
Up to you. Go. All right.
All right.
I'll try to make answers even shorter. But you don't ask the easiest questions, so.
Thank you. Jean McKnight from the Needham League of Women Voters. I'm a retired attorney, and although
Oh, okay.
I never...
Did I get anything wrong?
No, not as far as I know. I never argued a case at the federal level. My concentration was in municipal law and representing cities and towns. But I'm very interested in what's going on now at the federal level. And it seems to me, you mentioned the Dobbs case, of course, which overturned established precedent of Roe v. Wade. It seems to me a very important case that increases the power of the courts is Loper, Bright Enterprises, that overturned what was called the Chevron deference. And what that meant is when Congress passes a law that says a particular agency is to write up the regulations implementing that law, the courts give deference to the agency's interpretation of the regulations, of the law, unless their interpretation is completely unreasonable or clearly in contrast to the law. And I think this is a very important case. It was a fully decided case, not a shadow docket case. And what I think it does is it gives more power to the courts and takes away what some might refer to as the deep state, So I wonder if you'd want to comment on that.
Yeah. Well, another way to think about the judiciary, there's also these books that say the most powerful branch, that the legal system in the federal system has gained power over time, has been able to grab power. And in part, that's a reflection of the idea, which you hear a lot, which is that Congress shouldn't make an independent judgment about things. It should leave it to the courts. That's not through American history, that was not the reigning idea in constitutional or administrative law. It was that everyone in the system could make some judgments about what was right and what was wrong. And if you were a member of Congress and you thought what you were doing was legally wrong, you shouldn't do it. You shouldn't wait for a court decision to decide that. So I agree with your underlying view, which is that by grabbing more and more things for it to decide and weigh, we'll decide this, we'll decide that, the court and the federal judiciary is gaining power. Now, the irony of Loper-Bright is great because Loper-Bright is this administrative law case, and I'm trying to explain this without having your heads just like fall asleep here, I have students and you get that look sometimes in the afternoon. I was telling Ellie Perkins about this, that you see that you look out and they're going. Try not to evoke that in this audience. But because administrative law sounds frightfully dull. It's actually, these days, pretty scintillating. But administrative law is about this administrative state, or as sometimes the Trump administration says, the deep state, right? So there's this irony here, which is that the administrative state is sometimes considered not part of the executive, it's like a fourth branch of government. There's the president, there's Congress, there's the judiciary, and then there's the EPA, the FCC, the FEC, all these alphabetical things. And one of the big fights we're having in law these days is, to what extent do these administrators and the system that they live in, which is partly a product of decisions of federal courts, partly a product of rules Congress has made, partly a product of decisions presidents have made, and partly a product of, let's say at the FCC, almost 100 years of FCC practice. This kind of beast of administrative law, to what extent is it legitimate? Or is it the case that really, if President Trump won the election, he's in charge of it all? None of these people should have any power. The president gets to just tell them exactly what to do, fire them at will, tell them what their budget is, tell them what their marching orders is, and in support of that, if you look at Article 2 of the Constitution, it doesn't mention all these other people. It just says the president shall have executive power. But we've created this government where lots of people have executive power. So what do we do with that, right? So part of the fight is between the judiciary and these administrators. Part of it is between the president and these administrators. Loper can stand in for the idea that the judiciary gets to decide whether the EPA has the right interpretation of the law. But Loper and some of these administrative law cases could also be used against the president, right? So, for example, there's something called the major questions doctrine. The major questions doctrine says, hey, you administrators, when you decide to make a new policy on something really, really important, and you say, well, there's language in some statute that Congress gave us that kind of, sort of authorizes us to do that, that's not good enough. If Congress wanted you to do it, they would expressly authorize it for whatever we decide are major questions. Okay, so that gives a lot of power to the judges. But you can turn this around and it can be used as a vehicle against President Trump. Hey, when Congress said that in an emergency you could have tariffs, is this an emergency? And if Congress really wanted you to have such extensive power to unilaterally impose tariffs, wouldn't they have expressly given that to you? Under the major questions doctrine, I'm sorry, we're going to have to strike down all your tariffs. And there's a case going through the federal courts right now where that's exactly what the judges ruled. So this major questions doctrine and this new will decide if it's really the right thing is something that can be used against the administrators and the deep state, but it also can be used against Trump.
In the Biden administration, there was a commission set up to look at the Supreme Court. And two of the things that they commented on were that we are the only country where there is no term limit on Supreme Court justices. And the other thing that I remember them commenting on was having a system where the judges were term limited in a way that from one presidency to another, they would get to appoint a certain number of judges. So I guess my first question is, what would it take to make either one of those changes? Is it?
Probably you have to amend the Constitution.
Yeah.
Unfortunately. And by the way, those ideas would be overwhelmingly popular among my tribe, the political scientists who study the legal system. We all think it's insane not to have term limits. But it's the product of having, first, an 18th century Constitution. I mean, first of all, when they designed this, state governments were by far more prestigious. Being the Supreme Court Chief Justice of Massachusetts was way above being the U.S. Supreme Court Justice, because the state courts were way more important back in the day. They were designing government for a completely different time. And, they slipped in this lifetime appointment. I think they probably figured most people would just, withdraw and do something more important at different times. So the way it's evolved is quite different from maybe what they expected. And the real tragedy of the Constitution is, remember, they were writing pretty much the first written Constitution. So I always tell my students, it's like the iPhone 1. On one hand, amazing, the iPhone 1, it's an amazing thing. On the other hand, if you had to use the iPhone 1 on a daily basis, you would go insane, right? Because it's, it's built for a different time. And unfortunately, the fatal flaw was, without realizing it, I think, they made it incredibly hard. Like, maybe among all countries in the world, there's maybe one country where it's as hard to amend the Constitution as we did. And that's really sad, because my personal view is that the framers themselves were tinkerers who liked to play with things and who had no great reverence for the people who came before them and said, we'll try something new, But they unfortunately created a system that is really hard to adapt in the most straightforward ways.
Thank you. I'm Diane Siegel from the League of Women Voters, Sudbury. My head is spinning right now, so I don't know if I'm going to get this in a succinct manner. One of the things that I'm thinking about, because you've inferred it and then spelled it out in some instances, when you're talking about the different levels within the judiciary system and the dynamics that exist or doesn't exist, and I'm also thinking about that dynamic, and then people who are being educated to be political scientists and lawyers, and the impact that has as they move forward to possibly consider these roles in the world that we're living in today, because I think it has traumatic influence. That's the first question. The second question is, we're all sitting here learning a lot from you, and we talk to people outside of here. What can we do as a takeaway from here today that we can have an impact?
Oh, interesting. Oh, that's a good question. Wow, that second question is kind of blowing my mind. I have to think about that a little bit. I've been thinking about your first question quite a bit because I have a textbook that's widely used for undergraduates. It's like a pre-law textbook, and it's an introduction to legal reasoning. And it has chapters on constitutional law, on administrative law, that's the Loper-Bright stuff, on common law, which is the ordinary law, and statutory law. And the con law chapter and the whole book was a real challenge to revise in the Trump administration, because a lot of it's about the rule of law and what is the rule of law and what does it mean to go against the rule of law. And you can be without meaning to, you can become very dark about some of this stuff. And one of the things me and my co-author tried to remember as we were writing this is you got to be hopeful. You got to give young people hope. You got to show them what are the opportunities, what is the right way to think about these things, and the traditions that we have in the United States of the rule of law and good legal reasoning. And so I think it's important to push back against a kind of really seemingly sophisticated, but I think too simple cynicism about how courts work. Like, as a political scientist, I don't think it's bad to say that, okay, by the way, this judge who made the ruling was appointed by Barack Obama. But it really appalls me when the newspapers and television don't even give you what the arguments were. They just say, here's how the judge ruled. And they don't even bother to educate you about why they ruled the way they did, or at least how they explained what they did. That's legal reasoning. That's what I care about. And the most important check on judges, and the reason people are so upset about the shadow docket stuff, is because the way judges are checked ultimately is they have to explain their rulings to a community of lawyers who will either say, that makes no sense at all. What the hell's really going on here, right? Or they say, okay, maybe I disagree with that, but you do have a reasonable take on this point, right? And I think if there was more of a sense of how that community works and how legal reasoning works, there would be less of a sense of, well, the federal judiciary, the state judiciary, these courts are just like politics everywhere else. That's an oversimplification. It's not true that it doesn't matter who appoints the judges. That isn't true. But on the other hand, as we say in the book, it's a different kind of politics. It's a different way of making decisions than your mayor or your school board or your member of Congress makes. And I wish that when we did civic education, we did a little bit more education about that.
So I just wanted to say, I thought I noticed a bunch of student-like people sitting.
There you go.
Yeah.
Who are brave enough to ask questions.
I would love one of you to ask a question.
Hi, all. Yeah, we're student people. We're actually members of the Wellesley Committee for Political Engagement.
Cool.
And I'm the political engagement chair, so hey. Yeah, thank you for having us. I have a lot of questions. One of which is about, like, I understand that maybe Trump is not winning as much in the higher courts as we think. But there are still so many people who are being deported without due process. And that is very sad. And sad is not even the right word. It's wrong. And I think I'm just wondering, okay, we can have hope about SCOTUS maybe, but how do we have hope to fight for these people and with these people who are being detained without the rights that we have been given?
I mean, there is a massive legal mobilization, against the Trump administration, and there is an effort to give counsel to all these people. And, one of the cases that we wrote about in this book that's coming out next summer is the Abrego Garcia case, and that fight continues. But it's been a fight. And I think that with deportations, sometimes people are deported, but it doesn't mean that the legal struggle is over for them. It continues. I don't necessarily agree with the way it's always been handled, in the sense of, I think that pending the decision about their deportation, they should not be deported to third countries or things like that. I think that's unfair and wrong. I agree with you on that. But it's not the case that there's large number of deportations without any kind of legal counsel. That's just incorrect. There is a fight going on. And there's lots of lawyers out there who are offering assistance. And that's what's going on in the United States right now. And that story has to be told as well.
So I have a question, because someone asked earlier, what can we do? And you mentioned tonight the Supreme Court actually does pay attention to public opinion. So this summer, myself and several of the other women in this room have been organizing rallies all summer long, and our next big one is on October 18th, which is a nationwide No Kings rally. And I'm wondering, is the Supreme Court watching that? I mean, if we get hundreds of thousands of people out, are they going to notice that?
Right. We don't have any direct way to know. They're not going to say, oh yeah, boy, that rally. Better think twice about the ruling I was going to make. But there's pretty good evidence that things like that do have an effect on the federal judiciary. The feeling about how things are going for Trump, I think, is going to have an effect on how these cases come out. And notice, we've just been talking about these injunctions. Almost none of these cases, it's going to take several years for the ultimate disposition of the birthright citizenship case. This one cynical part of me thinks they're just going to wait out the Trump administration. And as soon as he's out of office, they'll announce, yeah, he was wrong in this case, 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 he was wrong in this case. And I think something like that probably is going to happen. But the other thing is that, if his support continues to slide, and then you have an election where Democrats take over the House or maybe Congress, it will have an effect on the judiciary. It's not conscious, but unconsciously, I do think it has an effect.
Any more questions?
I've exhausted you all.
All right, what do you have? One professor.
professor to another. What do you have to say?
Uh-oh. Oh, now I'm
I'm
in
sorry,
trouble.
I'm not a legal professor. I'm a health economics at Brandeis. But my question is about corruption. And there have been lots of questions about the ethics of the Supreme Court justices, and they seem to ignore the questions and just sort of seem to take lavish vacations and do other things that other judges. Do you want to comment about? Would you agree with that?
Yeah, not too much.
Characterization?
Yeah, not too much. I haven't followed. I haven't followed this that closely. There have been a whole series of scandals involving Justice Thomas and I think a couple other justices, Scalia, where they get paid vacations and events from people who have an interest in some of the cases percolating in the federal courts. And there's a question why they aren't more subject to ethics rules. And part of this is about the separation of powers. Who are you going to put in charge of disciplining the Supreme Court, right? You're impairing the separation of powers if you establish some authority over the Supreme Court, which means the Supreme Court really should be really carefully policing itself and have clear rules and all kinds of procedures so that this never comes to that. And they haven't. And this is a problem. I think it's a big problem. And they should clean up their act. I guess they have developed a few guidelines, but I would like to see a lot more. I personally also just have a problem with the whole phenomenon of Supreme Court justices becoming celebrities. I had my doubts about RBG worship. I think the best judges and justices are ones you don't hear from, and they aren't outsized celebrities. They're back there, I've taught a couple courses to judges. Most state judges and whatever, they're not allowed to even they don't write editorials. They don't even write reviews for, like, if they're into music, they won't even write a review of a record. They shouldn't be celebrities. They shouldn't be out front. They shouldn't be people you read about in the newspaper or any of this kind of thing. And they shouldn't be so engaged, with supporters or proponents of things. They should be a little monkish. Souter was the ideal, right? He was a little too much of a monk, right? But he would just go back to his New Hampshire cabin, when he was done at the Supreme Court, and that was it. Didn't talk to anyone, right, except a few close friends. I wish more Supreme Court justices were more Souterish and less, I don't know, RBG, Scalia, Thomas-ish, yeah?
There are a lot of people who believe, you alluded to this, that this is a rogue court. So, and you mentioned that the number of justices is not set. So what do you think we should do?
Who's the we?
Well, what?
The League of Women Voters?
No. Yeah, maybe. Could we? We could study it. If we study it and decide, yeah.
The problem with enlarging the Supreme Court is it's, as you can imagine, for a partisan reason, it's a little bit like this gerrymandering stuff, right? Like one side does it, then the other side does it, then it pretty quickly collapses into ridiculousness. One would have hoped that kind of along the lines of there was discussion for a long time about coming to some kind of decision, some kind of agreement in Congress, in the Senate especially, about this, where you start to set up some norms about how people vote for judges when they're nominated. That would be something, but we're in such a partisan era that it's hard to even imagine that. But we're definitely going to hit a crisis point with this, because if you have divided government where the Senate is in the hands of one party and the presidency is in the hands of another, it's becoming hard to imagine how you will get any appointed judges, any appointed justices, right? And so we're going to limp along with years whenever we have divided government where we just won't have any appointments. And I think at some point people have to start thinking, maybe we have to make some kind of bipartisan agreement about how we handle this. But we're not there yet.
All right, is there?
Do we have one last question?
Something cheerier? I don't want to end on such a down note.
Which was the question, is what should,
Whoever come to us, what you can tell us that we should be taking away from?
Oh, well, I would say that more, like, okay, it's a civic organization, League of Women Voters, and I have a textbook on legal reasoning. People should learn more about how these cases are actually, without having to read the 100 pages, educate yourself about what the actual legal issues are. And you'll see that a lot of times you might, on the surface, think they're really simple, but when you get into it, you realize actually some of these cases are pretty complicated. And they may go against your kind of partisan opinion if you start looking into it. So I would say, I would put a pitch in for a little bit of civic education, learning more about the Constitution and constitutional law, and what's really behind these decisions, and why these very, very smart people are disagreeing about these cases.
How do you recommend we do that?
Oh, good question.
so the question was, how do you recommend we do that?
Well, there are, one thing that's happened with our move from broadcasting to narrowcasting is that if you're interested, there's a lot more out there. For someone like me, I have access to almost every day law professors immediately analyzing stuff that goes on at the Supreme Court, which is a level of sophistication I never had before. But you also have access to some remarkable things. And I would put out there, for example, if you're interested in constitutional law, every once in a while go to something called SCOTUS blog. SCOTUS blog. It's a very high quality, nonpartisan thing. It has partisans on it who will give different opinions, but you will get a lot of education. If you read something in the newspaper or hear something on TV, and you go, I don't understand that. Just go on SCOTUS blog and read it's only, usually 3 or 4 pages. If you really want to nerd out, they will link to the actual cases, and you could read the 50-page lower court decision and the briefs filed by the parties, and you'll really spend an afternoon on it. But if you don't want to go that deep, at least you get a higher quality of education, and encourage other people to do these kinds of things as well. Yeah.
I want to piggyback on what you're saying.
Hold on, let me just give you the mic.
Okay, sorry. I want to kind of piggyback off what you're saying when it talks about outside of people in this room. So civic education, so in our league, one of the things, and it's a state law since 2018, that middle school students and high school students have to learn about civic education, and every school district does it differently and embraces it differently, but translating it to helping the students even learn about voting. So it's how do we also teach the younger generation, not just the people in this room, about bringing it up the ranks and educating them at an earlier age.
Yeah. Well, I think it's important. I guess you got to get entertaining, because everything has to be entertaining these days. But yeah, finding ways to get people interested and knowledgeable at an early age in these things, and not to fall for the way social media and some of the terrible stuff that young people are exposed to on the internet, the way that's covered, is very corrosive, I think, to a lot of this. So some attempt to push back against that is all to the good, I think.
All right, well, thank you so very, very much, Professor Burke, for coming tonight.
Thanks.
And thank you, Rama, for hosting. And I also want to thank my little team of Ellie and Reka and Raina, who did all the publicity. Thank you so much. And please, if you're not a member, please join. And I think that the professor will be hanging out for a few minutes. Maybe if you were too shy to ask your question, you
I'm
might
sure
get one in.
people will want to talk to you all night long. But this was fabulous. Thank you.
Thanks. That was a pleasure. Yeah. Didn't ask me any easy